Hello, I'm Alice Johnson, the IBA's multimedia journalist. Today I'm joined by Sir Brian Leveson, the Investigatory Powers Commissioner and a former senior judge. Thank you for making the time to speak today.
Not at all.
You spent much of your public life examining powerful institutions, the press, the courts, law enforcement and the intelligence community. Is there a common lesson about how institutions lose public trust?
I think the problem about public trust is that things happen without necessarily being properly explained to the public. Now, in some circumstances, the failure to explain is inevitable. National security may not permit it in relation to investigatory powers. I think the courts have become much better in explaining to the public what they're doing and why. But there is no doubt that there has been an explosion of interest in our public institutions, which requires all of us to play a larger part in explaining what we do and why we do it, which is one of the reasons why I'm pleased to be here this afternoon to talk about investigatory powers.
That's great. And of course, you've been asked to devise systems of accountability. What do you think meaningful accountability requires?
Meaningful accountability requires those that are being held to account to be open and frank about what they're doing and why they're doing it. Oversight is fine, but there is no way that any oversight body can see everything that all the bodies which they oversee undertake. So it does require a relationship between the body being overseen and the overseer of mutual respect, so that the overseer can be satisfied that there will be brought problems that have arisen in the course of the business that they are overseeing.
Okay, great. And to turn to your current role as the Investigatory Powers Commissioner, where you're responsible for reviewing the use of investigatory powers by public authorities, what would you say is the hardest part of that role?
The hardest part, I think, is probably trying to explain what we do and how we do it. So I'll use the opportunity to do just that now. So oversight of the intelligence community and indeed the police forces and the 600 bodies that we oversee takes a number of forms. In relation to the intelligence community and the police, there is the concept of double locking warrants. So if the intelligence community want to intercept your communications or to look at your email traffic, they need a warrant signed by the Secretary of State to do so. That warrant requires the person seeking the warrant to identify its objective and to demonstrate why it is necessary, proportionate to do so against the objective. Consideration also has to be given to whether there is any collateral intrusion and the extent of such collateral intrusion, and whether there is a less intrusive way of doing the same thing. So in relation to some powers, chief officers of police can authorize, and in relation to others, it has to be a Secretary of State. But then they come into my office for one of the 13 or so judicial commissioners, who are all retired, very senior judges, to look at the application and consider whether there was material upon which the relevant decision maker could reach the conclusion that it was necessary, proportionate, against the objective of the warrant. So that's one half of what we do. The other half of what we do is we inspect the agencies and the police, and indeed, as I say, a total of 600 bodies who have some limited investigatory powers, there might be surveillance powers, to check two things. First of all, that an application for a warrant is justified by the material that is available to the warrant seeker. And second, and particularly important, is that what they did was what was said on the tin, no more than what was said on the tin. And inspectors go into these bodies in relation to the intelligence community many times a year to inspect their use of various powers. And that leads to a report, all of which I sign off. And in that way, we hold the relevant warrant-seeking body to account. And we write an annual report which identifies the extent of what we're doing and why we're doing it. And it's important to underline that great care is taken about these, and the truth that Google and Amazon probably know far more about you than the state does.
Sure, I think I would probably agree with that. And that test of necessity and proportionality, I found that interesting. And can you explain a little bit more detail about how you kind of balance national security needs with concerns about privacy and civil liberties, especially in an age of rapidly advancing technology?
Well, I think that's a good question. And I should perhaps have explained that each of these powers is being exercised against a statutory requirement to consider the privacy of the individual concerned. And that's the balance that we're constantly seeking to strive. But it isn't a binary decision, privacy or invasion of privacy. Everybody has to consider what's behind the invasion of privacy. I anticipate that very few people would object if there was a national security angle to the reason for the invasion of privacy. If there was the detection of very serious crime. All these are the reasons why warrants are sought. And the choice is the national security or the crime sufficiently serious to justify the invasion of privacy? I ought to add that in addition to the most intrusive powers, my office is also responsible for authorizing communications data, and that is the metadata of calls, not content, but what device called which device, when, for how long the call lasted, and through which cell sites it passed. And police investigations rely heavily on CD, communications data, for the purpose of proving the commission of crime. And all that is authorized by authorizing individuals, not the judges, but civil servants, acting for me, in other words, independently of the government, to decide again necessity, proportionality, collateral intrusion, and less intrusive ways of achieving the same result.
Right, yes. And thinking about the importance of transparency, which I know you've already mentioned, obviously most oversight bodies operate in the public and yours necessarily deals with secrecy. How can the public trust oversight that it can't fully see?
Well, it can't fully see it, and I would hope that most members of the public would recognise that where national security is concerned, there inevitably has to be a degree of secrecy. But the annual report, which is published, I think, for 2025, coming out certainly in the autumn, identifies the number of warrants, identifies the errors we found, and gives as much information as we can put into the public domain. If the Prime Minister feels that there is material that shouldn't be in the public domain, then he can make that point. But I put into the public domain what I can. So I am frequently asked Why is it there are so few warrants refused? And that's absolutely right. Very few warrants are ultimately refused. Ah, they say, you are a rubber stamp, you're not paying any attention to them. Absolutely not. The warrant-seeking authority wants the warrant. They know what the senior judge who will double lock it has to be satisfied about before he grants the warrant. And therefore, if they want the warrant, they've got to jump through the hoops. And that's what happens. In addition, they can, under certain circumstances, come and ask me about what might be a novel or contentious issue. And I can give you a public example of when they've done that. I say public because it's been ventilated in full in the courts. So there is a mobile phone system called EncroChat. And EncroChat was used almost exclusively by very serious criminals because it was heavily encrypted. And what happened was the server was infiltrated and the National Crime Agency were offered the product of that infiltration. And in order to have it, there had to be a warrant. And the NCA came to me to discuss this rather unusual circumstance. And they then ultimately applied for a warrant, which was granted first by one of the judicial commissioners, and the second one actually was granted by me. The result of which is that there have been many, many arrests of very serious criminals. Tons, literally tons of dangerous drugs have been obtained and millions of pounds seized, firearms. Really serious crime has been detected because of this particular invasion of privacy.
Sure. And did you see any resistance from the owner of that messaging platform? I wonder how the corporate angle comes into this.
The owner of the messaging platform, I think, sent a message out when he found out that it had been infiltrated, destroy everything.
Right.
I mean, this was serious crime. And the police then could come and they had the messages, they could come and seize, and their challenge was to attribute some of the phones to the people who were arrested. And not infrequently they said, oh, it's not my phone. Of course, if you've got the photograph of your dog on the phone, it becomes a bit more difficult. And the other feature of it is that, of course, the whole thing was challenged. It's been to the Court of Appeal Criminal Division twice, the Court of Appeal Civil Division once, the Investigatory Powers Tribunal once, suggesting that this was an interception which wouldn't be admissible in court. The court ruled that it was an exploitation which was admissible in court. And I'm not surprised people fought the cases on the basis that if they were successful, they would succeed and prevail. And if they were unsuccessful, there was a very good chance they were going to be convicted of very serious crime.
Sure. Thank you for that example. That was really interesting. And I want to move on to talk about the Investigatory Powers Act. Obviously, it established your role and overhauled investigatory powers. Do you think that the legislation is still fit for purpose a decade later?
Fit for purpose is a big phrase. So the Investigatory Powers Act did not come out of the blue. Prior to the Investigatory Powers Act, there were three commissioners. There was an Intelligence Services Commissioner, there was a Surveillance Commissioner, and there was an Interception of Communications Commissioner. All three were retired senior judges. And what the Act did, which followed Snowden and the revelations of Snowden, was bring the three offices together. Those commissioners merely oversaw ex post facto, and the Act gave me the responsibility, or my predecessor actually, but then me, of double locking, in other words, ex ante authorization. The trouble is that attempts were made to make it technology neutral, but it was impossible in 2016 to visualize what technology would achieve in 2026. For example, SIM cards in fridges, the Internet of all things, SIM cards in cars, So what is communications data is a concept which is defined in the Act, but which doesn't wholly fit with how the internet is used today. So there is, I say struggle, but there is a challenge to construe the legislation to cope with modern conditions. But the real trouble is that we cannot legislate for what we know nothing about. And the technology will always be in advance of legislation. Legislation takes a long time. It has to be thought about, it has to be written, it has to be debated, and it has to be passed. All that takes years, whereas in that 2 years, the technology will have moved on. So it does what it can with the present conditions. Does it need constant refreshing? Yes, of course it does. But I'm not sure we can ever go quickly enough, because I don't think you can really make it technology neutral to cover everything.
Yeah, no, that makes sense. And moving on from your role as the Investigatory Powers Commissioner to thinking about your review of the criminal courts. Obviously in 2024, you were asked to conduct this review triggered by the unprecedented Crown Court case backlog and delays in the criminal justice system. Your review begins from the proposition that delay itself is an injustice. At what point does delay become a denial of justice?
Well, everybody might have their own view about that, but let me just spell out some of the real challenges. The first is that if a victim of crime could have to wait years before their case is heard. Now, if, for example, a young woman or a young man is the victim of a sexual assault, they need to be able to get on with their lives, but they can't really if they've got the case hanging over them. So to require a victim to wait years before their case can be heard is a terrible burden, and many withdraw. Well, if the victim withdraws from the process, that's a denial. Whether or not the defendant is guilty, there hasn't been a resolution of the issue, and society requires these issues to be resolved. It's not just victims, it's witnesses. And if you've had to wait for years for your case to come to trial, the victim may withdraw, the witnesses may have forgotten, and the whole system therefore becomes much, much more difficult to ensure justice can be achieved. And it's not necessarily wonderful for defendants. Some defendants will game the system, there's no question. They'll be happy for it to be put off forever in the hope that the case just goes away. But there are defendants, perhaps some people who've been accused of sexual assault, who will feel they can't move on with their lives, who have to declare to potential employers, well, I'm waiting for a rape trial. That'll be a wonderful way of getting a job. So they are equally disadvantaged. So they're listing cases into 2029, and we're in 2026. So is that a denial of justice? I believe that it is. And others believe it is too. The challenge is what to do about it.
Yeah, and you definitely gave some, a whole host of recommendations about what to do about it. The most controversial one obviously being to restrict the right to jury trial significantly. Has your assessment of the constitutional value of juries changed, or more just what the system can afford?
All right, let's just unpick that a bit,
Yeah,
can we?
Of course.
So I have been accused of blaming juries. Juries are not to blame. When I started at the bar, I regret to say 56 years ago, I could do 2 trials in a day. And I remember an occasion when I started a 3rd trial with 2 juries out. But life has changed. And now trials take, day and a half, 2 days. Why is that? It's because the system has changed. And I'd like to just unpick that with you for just a minute if I could. So in the 1970s, you might have a victim, a witness, some other witnesses, unlikely to have much scientific evidence, but there could be a bit of forensic evidence. We didn't have mobile phones. We didn't have computers. We didn't have any of that material. We didn't have protections for defendants. So the judge's rules meant that police officers would compile their notebooks hours after the event and say, this is a true record of what he said. He did say it's a fair cop gov. You got me banged to rights, perhaps. But that was all there was. There was no disclosure of unused material. So it was in the early 70s that the Attorney General issued some guidelines saying the police had to disclose the names and addresses of witnesses they'd interviewed, but nothing else. So over the last 50 years, we've developed our procedural protections to improve the fairness of trials. We've had the Police and Criminal Evidence Act, which now means all interviews are tape recorded, and sometimes now video recorded as well. We've had the disclosure of unused material. We've had special measures for victims to protect their identities and their visibility from the defendant. We've had protections for defendants and intermediaries, where for the neurodiverse, we've had a greater explosion of the need for interpreters. We've had evidential changes, hearsay, bad character. All these are splendid protections, but they all cost time. On top of that, the evidence has changed. We now have CCTV. We have body-worn cameras. We have this hideous device called a mobile phone, which has so much data in it that has to be looked at, that if you really had to print it all out, it would go the height of a very large mountain in paper. All that takes more time. So it's not jury's fault, but we've got to use our resources as effectively as we can. There are a limit to the number of courts there are, even if we're sitting as many days, and they're now sitting more days than they ever sat before. And there are a limited number of judges and a limited number of barristers and solicitors prepared to do criminal defence work. We've got to cope with all those. Equally, of course, there is also an enormous problem of prison capacity, which means that prisoners are held in prisons far from their home and far from their court. And that means that the prison escort service is bringing people late, which means less time in court. Judges always blame the escort service, but if the prisoner is 2 hours away, it's going to take 2 hours to get them there. And there's a limit to how early you can get them out of their cell. All that has added to the time. So what I've suggested is we need to rebalance what justifies a jury trial because of the, I believe, very substantial extra time that jury trials take. Now, rebalancing the system is something we've done many, many times. I'll give you an example. In 1968, the breathalyzer was introduced for those who drive motor cars while drunk. Enormous challenge to it, and it was originally trial by jury. So if you were breathalyzed, you could elect jury trial. In 1988, the law was changed. You can no longer elect jury trial for breathalyzer offences. The earth has not fallen in. Another change. There was a principle of law which was bedded into our settlement that if you were acquitted, you could never be tried again. And the law was changed to permit prosecution in double jeopardy if there was new evidence. Again, enormously challenged by the professions as outrageous. It would be state oppression to prosecute somebody who'd been acquitted, and it would be the end of the world as we know it. Well, the law was changed. There have been, I suppose, maybe a dozen or so, almost all, perhaps all, murders, acquittals in murder where there's some new evidence, perhaps because of forensic material. And I believe that every single one of those cases where the Court of Appeal has given permission to retry has led to a conviction. So I'm very comfortable with jury trials. I conducted them as a barrister for 28 years. I tried them and I sat on appeals from them for another 19 years. But how are we going to get through the work? Because if we don't find a way of getting through the work, our system will just become slower and slower and slower.
Sure. Well, if I may challenge you on it a little further, what would you say to people that argue that, restricting the right to a jury trial should really be an absolute last resort, and what we really need to do is fund the criminal justice system better? I know you've said that, that should happen, but why is funding alone not enough in your view? Increased funding.
I've just actually answered that question. There aren't enough courts.
Right,
there aren't
yes.
enough barristers. There aren't enough court staff. There aren't enough anything. Let me tell you, in 2024, 1,100 cases were ineffective. In other words, they got to court and they were called on for trial. There was a defendant, there was a judge, there was a jury, there was a court, there were the witnesses. But either there wasn't a prosecutor or there wasn't a defense lawyer, because there wasn't somebody available. Now, we need to train more lawyers, no question. But that's not something you do overnight. That's going to take years. And you've got to encourage people to come into crime. International law, or the commercial lawyers that operate within the international sphere, are rather better remunerated than legal aid, defense, or prosecuting lawyers. And that's a real challenge. So we need to do all that. We need more money in the system. We need more courts, more judges. We need judges to be fully trained. We need courts to be effective and functioning and not leaking. We also need a great deal more efficiency within the system to ensure that once cases are on, they're heard. There have been a blitz in some courts recently after the government withdrew the cap on the number of sitting days. But I regret to say that a large proportion of the trials that were then listed were ineffective for one reason or another. So absolutely we need more money. And indeed, I think the government have allocated more money. And if you read part 1 of my review, you will see how poorly justice has been served over the last 20 years in funding terms. I can't remember the precise statistic, but it's really shocking.
Yeah.
We need more efficiency, but funding and efficiency alone won't do it. We've got to pull every lever to get rid of the backlog and make it sustainable. We don't want to get rid of the backlog totally, because you need cases time to prepare. But we absolutely can't be delaying cases for years and years and years. And the trouble is that as presently constituted, the government is rightly aiming against violence against women and girls, mobile phone theft and shop theft. Well, all that is going to add to the number of cases coming into the system. It won't detract from them. So more cases are coming in, and we've got to find ways of dealing with them more effectively and more efficiently. So I'm very keen on juries in appropriate cases. The question is, what is an appropriate case? And where do you want to draw the line? Why do I think it's necessary? Well, I'll give you a different example. I am not suggesting for a moment that rape cases should be tried without a jury, but they are tried without a jury in youth cases. So some youths are tried for rape in the youth court by a district judge magistrates court. And if you think about an acquaintance rape, the allegation that boyfriend and girlfriend are together and she says no and he persists, which is, I think, a not uncommon complaint. That trial is the same whether it's the defendant is 16 or 20 or 18, so youth or crime. Now, there are district judge magistrates courts who try the cases in the youth court. And some district judge magistrates courts are also recorders and are sex ticketed to try rape in the Crown Court. So I have asked them how much time is saved. Not because I'm ever going to suggest rape shouldn't be tried by a jury, but because I'm there comparing similar cases tried by a judge alone compared to tried with a jury. And they make it clear that in their view, and I asked in an open way, I didn't lead them to an answer. I said, is there a time saving? Yes. The youth court trials take half the time of the Crown Court trials. Now, my review, the analysts suggested would be a 20% saving. And if you read my review, you'll say, I think that's pessimistic. And I do think that it's much quicker than that. If you go to Canada, most defendants who could have trial by a jury elect to be tried by a judge alone. The advantage is they get a reasoned decision, which if the reasons aren't good enough, they can challenge. But they know why they've lost. In this country, if you've had a jury verdict, you don't know why you've lost. The judge has summed the case up to the jury, but then the jury just say guilty or not guilty. They don't say anything more. Whereas a reasoned decision provides, rather as it says on the tin, reasons.
Sure. And I know you've kind of already alluded to this in your answer, but is there kind of a line, just out of interest, a line where you think restricting the right to a jury trial would go too far?
Well, in my review, as you probably know, I suggested the line should be a sentence that was in or above 3 years. Yeah. You can draw the line where you like, but you've got to make sure you get it right. In the sense that you want some cases to continue to be tried by a jury, but you need some simpler cases not to be tried by a jury. I also suggested that in relation to the most serious frauds, there should be a judge. But I'll let you ask me about that.
No, please feel free to expand on that, because that is really interesting. I know fraud is traditionally very complex and it's kind of difficult to explain to juries sometimes the intricacies of the cases. So,
you've answered your own question. So
I used to do court reporting on fraud trials, so I used to struggle. So, but
thank you very much. Yeah. I do not understand derivatives. It may be you do, it may be lots of people do, but I don't. So to expect 12 people who have no experience of forensic matters, in other words, court hearings, to understand fraud trials is, I think, an enormous imposition. And furthermore, these trials can take months and months, and you could be called for jury service, and you think you're doing 2 weeks, and suddenly you're in a trial lasting 9 months. Your life is turned upside down. It may be you'll be lucky and your employer will continue paying you, but many don't. There is an allowance, but it's not great. And it may be if you run your own business, you say, well, how can I run my business if I'm got to come to court for weeks or months? And it's worse than that. So there has been a trial recently in Southwark, which is the fraud centre, as you know. The trial was a complex tax allegation. The trial took 7 weeks. The jury were out for 2 weeks and then were discharged as unable to reach a verdict. So that's 9 weeks of court trial, and it's all got to be done again. Well, you don't have that if you have a judge providing a reasoned decision.
Sure, well, I could ask you about this all day, but we should probably move on to the next section, the next issue that I want to talk to you about, which is the Leveson Inquiry. So looking back at your career, I think the public would probably most strongly associate you with that. A public inquiry you chaired into the culture, practices and ethics of the press and its relationship with the public, police and politicians, with a report published in 2012. In your opinion, was the Leveson Inquiry implemented, resisted or buried, and is there still a need for a part 2? Big question, I know.
Yeah, well, okay. So I haven't talked much publicly about the inquiry, but I'll answer at least some of your question. Was the recommendation of the inquiry implemented? Not really. So I recommended that there should be self-regulation of the press. In other words, they should be able to set up their own regulator, but that the regulator had to follow certain rules. In other words, I wanted the regulators to be regulated. So that, again, they did what they said on the tin. In other words, they weren't just complaint handlers, but they were actually proper regulators. And that was my recommendation. But as I delivered the report at lunchtime, by 3 o'clock, the then Prime Minister had said that I had crossed a Rubicon because I was suggesting state regulation of the press, which I absolutely was not. And indeed, even today, where some people say we ought to have part 2 to the inquiry and implement what I said in part 2, they say, oh, this is state regulation of the press. Absolutely not. I never, ever suggested state regulation of the press. And regulating the regulator is not state regulation of the press, because the regulator then is free to make decisions according to the code, which they think is appropriate. The trouble is that if the story is big enough, the rules go out of the window. So that's the answer to the first part of your question. The second part of your question, I opposed the abandonment of part 2, and I'll tell you why. I was criticised in relation to part 1 for not dealing with the media. Of course, social media in 2011 was a very, very different animal to that which it was today. And I think in my report I spoke about it chattering in the pub, which I probably regret now because it's not that now. And I was criticised for not dealing with social media, but the critics did not read the terms of reference. The terms of reference for part 1 were specifically concerned with the press. In other words, the printed media, the papers, the newspapers. Part 2 was concerned with the media. More generally, it was a much more open question and could have incorporated the broadcasters and indeed social media. So I was very keen that there should be part 2, and I said as much to the then Secretary of State for Culture, Media and Sports, who was Matt Hancock. And I said, if you want to abandon part 2, you must write to me and I will reply, and both your letter and my letter have to enter the public domain. And if you don't publish them, I will. And therefore, if you research it, you can find my letter emphatically believing that part 2 should happen. What the answer, the political answer was, well, we're discussing it with social media and we'll sort it out with them. Well, right. They've really done that. Yeah,
that's really interesting. Thank you for sharing that. And it kind of, I guess, leads on quite nicely to my next question, which is there anything that you would frame differently today, knowing what's obviously happened to the media ecosystem and social media since 2012?
Yes, but that's all I'm going to say.
Is that what you're going to say? Okay, I can't tease anything else out
No,
of
I'm
you.
afraid not, because I would want to think about it and I would want to formulate proposals. I think it's a sadness that they abolished Section 40 of the Crown and Courts Act, which gave the teeth to regulation of the regulators. So it was much criticised on the basis that the papers were saying that they would end up paying costs even if they won cases. And that's the idea for Section 40, if you know what I'm talking about.
Yeah, I do know what you're talking about.
Was that the regulator had to offer an arbitration system so that little people could get redress rather than have to face these behemoths of newspapers with lots of money and lots of resources with no resources themselves at all. I'm not talking about the actors and the famous people. I'm talking about the little people who are traduced or defamed or whose privacy is invaded by the press, but who haven't got the resources to start litigation. So I said the regulator had to offer an arbitration system. Why did I have that idea? I'll tell you. It came from something that Lionel Barber, then the editor of the Financial Times, said to me. What he said to me is, my problem is not that little people can't sue me, is that oligarchs can sue me, and their financial punch is far bigger than my financial ability to defend. So how can I deal with the oligarchs who try and muzzle my investigations? So my suggestion was that there should be an arbitration system which had to operate. And if the little person, if the complainant wished to arbitrate, but the newspaper said, no, you can't force somebody into arbitration, so the little person had to go to court, the judge should be able to say, well, actually, this could have been solved in arbitration very much more quickly, very much cheaper. Therefore, although you, the press, have won, there's no reason at all why the victim who could have gone to arbitration, had you offered a system, should bear the cost of having to bring the proceedings. Therefore, you must pay your own costs. And maybe you have to pay the costs to the other side too. Equally, if an oligarch said, I'm not going to arbitrate, I want to use my financial muscle, the press could say, well, even though the oligarch has won, I was prepared to let them arbitrate. And if I lost, I lost. Therefore, they should pay my costs, even though I lost. And the press were very happy to emphasize the former, because, of course, most of the press are not attacked by oligarchs, but were quieter about the latter. And I believe that that was a fair system. And indeed, in commercial litigation, if you offer mediation and it's not taken up, the judge can take that account of that when it comes to costs. So I wasn't doing anything that was, as it were, heretical, I didn't think, although the press certainly thought I was.
Sure. No, that's really interesting, and kind of that idea of press reform capturing both issues on either side of kind of good journalism being intimidated by oligarchs and bad journalism, being conducted unethically. So yeah, that's really interesting. I was going to ask you about that, but you already explained. So the inquiry obviously examined the culture, practices and ethics of the press. Do you think that the culture of the British press has changed, or merely the technology through which the same pressures operate?
I think the technology has changed enormously the challenges facing the press. What should happen now is for another day.
More time to think about. Great. Let me figure out what else I was going to ask you. I think just to kind of bring everything together that we've discussed, looking across the press, courts and surveillance, what have you most learned about systems, culture and institutional power?
What has concerned me throughout my professional life, both as a barrister, as a judge, and as the Investigatory Powers Commissioner, and as conduct of two reviews or inquiries, is what matters are the people. I have been extremely privileged to have a ringside seat at the at the public discussion of the problems that people face. Defendants who barely understand the challenges facing them. Complainants who grapple with the system. In civil litigation, just the same. In balancing privacy and intrusive rights, where does that balance lie to protect the public, which is the first duty of the state, but equally to have regard to privacy implications and rights that each one of us faces? I'm not sure our adversaries, our hostile state adversaries, necessarily conduct their intrusive powers with the same controls.
Sure. A great way to end the interview, but thank you so much for your time. It's been really interesting to talk to you.
Thank you very much.
Thank you.